today's topic of Vivad se Vishwas bill is a very interesting and an important issue according to me, because it is in the nature of an amnesty scheme. Recently, this government's attitude is to see that there is more compliance by taxpayers and the general public at large. This government's efforts to see that we increase the tax base and that more people come and pay taxes, I think is a very important point to be noted. This year's Union Budget 2020 is also a good budget according to me. If you ask me to describe the budget, I would say it is a directional budget. It gives a direction to the entire country, to the entire economy, how it will project itself in the coming years. Its chart on agriculture, it starts on education, its efforts on social welfare, I think is excellent. However, as usual, on the tax front, it is a little difficult on various points. I come straight away to paragraph 126 of the Union Budget, which deals with the introduction of this Vivad se Vishwas scheme. It mentions the word scheme. In paragraph 126, the Finance Minister has made it very clear that the recent scheme launched on indirect taxes got phenomenal response, and that almost 1,89,000 cases were resolved. Keeping that idea in view, the objective is to extend it to direct taxes so that people come forward and finish off the litigations, because according to them there are more than 4,30,000 cases on tax which is pending all over India. Good thing, let me tell you, the effort of the Finance Minister, the Prime Minister and the government to reduce litigation is a step in the right direction. The scheme is also correct. But if you look into the entire scheme in a larger perspective, there are very many issues which arises. I will now come straight away to the point. One objective of the government and the scheme is reduce litigation. Second objective of the scheme, to ensure that people pay taxes correctly. Third, compliance issue. And fourth, that they should not be afraid of the tax department. With this background, first let me analyze the title. Vivad se Vishwas. Vivad means disputes. Jagara, disputes. Vivad. Say Vishwas. How do you go to Vishwas? So you come forward, pay the taxes, build confidence in yourself that you have paid the taxes, you come clean, and there is immunity from interest penalty and also prosecution to that extent which I deal it in my way. One important point to be noted first is the preamble. The preamble is just about 2 lines. Unlike other acts where there is a huge preamble. Preamble is only to settle the dispute resolutions in connection with tax disputes. Good thing. With this background, the only problem is, see, I am making it very clear, the scheme is good. It should be there. I am all in favor, but there are too many loopholes, too many difficulties, too many issues in the implementation of the scheme, and I hope the government takes it into consideration so that more and more people come and that more and more people take advantage, and that even the person and the chartered accountants and the lawyers understand what they are doing. Because otherwise it will be quite difficult. Let me start. About 15 issues I have picked up. First issue. Though the budget mentions the word scheme, nomenclature, if you say in the speech, Vivad se Vishwas scheme, below also the finance minister has used the word scheme, but it has come subsequently as a bill and thereafter as an act. So first let me tell you that. See, unlike all other schemes which we had up till now, all were schemes. This is the first time they have brought it as an act, a full-fledged act, because it's a bill and thereafter it will be an act. So first question which I am placing before you is, what is the difference between the scheme and the act? See, a scheme can be in the form of an act, but a scheme requires to be notified in the Gazette. Scheme is under the constitutional law and administrative law a part of delegated legislation. Per contra, an act, a bill, is converted into an act after it receives the assent, the consent of the Parliament and the assent of the President. It is an act, there is no notifications. So here you have a picture that instead of a scheme, this is an act. So it will be passed by the Parliament, it will come out as an act, it is an enforcement of the act. And just see one important point, I am taking it right away, I went it at the end but I am taking it away. It is for a short period of time. They say that it will be first installment etc. up to 30th of March, 31st March, then extended up to April. What happens thereafter? So the act will have to be repealed. Thereafter there will be no validity of that act. The act will cease to be effective, therefore the repeal provisions would thereafter apply. So first time a scheme, we had the last KVSS scheme, the other schemes, disclosure schemes, first time they have brought it as an act. And why? Intention is to see that people comply with it, better compliance, better enforceability, and therefore it is done in the nature of an act to show that the government is serious on the question of binding nature of the entire procedure. The second issue. The first part says the definition of specified date in section 21N it says that the specified date of this act shall be 31/1/2020. So the mantra is laid down, the benchmark of 31/1/20. Now just see the practical point. The budget was on 1st, this is 31, one day prior to that. Look at the point. Take a case, I am now on orders. Orders are passed, say on 20th January, 25th January, 30th January, 31st January. Genuine assessees want to avail of this scheme, say to file an appeal before the CIT appeals 30 days, to the tribunal 60 days, to the High Court 120 days. So now here is a peculiar situation where the order is passed. Of course you need time. Sometimes the orders are so complicated that you have to seek legal advice. You have to decide whether you want to take this issue, this ground, whether it is to be drafted properly. Now because of the electronic filing, the proper wordings in 100 words per ground, all this takes time. So what about genuine assessees who want to avail of this scheme, but orders are passed, but are precluded by an artificial method of a benchmark of specified date under section 21N. Because the specified date is a benchmark. Once you have a benchmark, you cannot go beyond that because the scheme does not apply beyond that. In such a situation, I think it is highly desirable because see, the objective is dispute resolution in the preamble. Therefore, the objective is what? The objective is to ensure that people take advantage, come forward. There are mistakes. But in such a situation, in the section, I think it is necessary to bring out an amendment to see that orders even which we are received late, but which fall within the parameters of the time of appeal or give some leverage so that those people who have received orders late can also take the benefit of this scheme. Take the third instance. In the definition in section 21A of appellant, the last 7 words, of which the important point is that the appeal must be pending. So appeal must be pending in a judicial forum, appellate forum. Now I am on the point of pending appeals, only one point. Appeal must be pending, no issue, correct, very simple. I am on the question of delay. Look at the issue. An appeal is filed, and appeal is filed along with the application for condonation of delay. Take situations. First, before the CITA, you file an appeal, you file an application for condonation of delay, and there, under section 249(3), subsection 3, there is a power given to the CIT to condone delay. The word is may. He may condone the delay, he may not condone the delay. Similarly, you have an appeal before the tribunal, fine, but there is a delay. Section 254 makes it very clear that tribunal may also have the power, after examination of the facts and circumstances, to condone the delay. Or take the High Court. High Court, sometimes appeals are filed by the department after a delay of 1,200 days, 3,000 days, even assessees, there are cases of huge delay. Now question is, when you are saying that there must be a pending appeal. Now if there is a pending appeal with delay, and assuming the delay is very large, say over 6 months, normally up to say about 4 or 5 months the court may generally be lenient, or the tribunal may be lenient, depending upon the facts, or 90 days, fine. But if there is a huge delay, there is an application for condonation of delay, can you say that the appeal is pending? Because the appeal is subject to the condonation being granted by the appellate authority. Answer: in my opinion, even if there is a delay, however long, but if there is an appeal pending, then the intention of the legislature in this scheme is to encourage people to come forward, and if the emphasis is on pending cases, then it should be taken into consideration. This is the point on delay. I come to the fourth issue. See, matter is before the tribunal. Another very tricky matter. Matter is before the tribunal. Tribunal hears the matter and says, we want to set it aside. So set aside matters. Sometimes, very often, according to your experience, clients say, no, we want to get the matter set aside. You please set it aside. At least the interest penalty burden will go. We'll again start the emails. Now, just look at this issue. Matter pending in the tribunal. Tribunal passes an order, set aside. CIT appeal doesn't have the power of set aside. Tribunal has it. Matter is set aside to the assessing officer for de novo assessment. Very typical order in the last line that all we have seen and heard the things. Therefore, the matter is set aside and restored to the file of the assessing officer to be heard, etc. after giving due opportunity of being heard. Standard last line. Now, what happens in such circumstances? The matter goes back to the assessing officer. Now, I am asking you a question. I am already in difficulty. I got the matter set aside to the assessing officer. Now I want to get the matter completed and get rid of it. Please note, when the matter is set aside for de novo assessment or set aside to the assessing officer per se, the demand or the assessed tax does not survive. Therefore, there is no appeal at all. There is no assessment order which exists. So all cases of set aside to the assessing officer, technically, not technically, really, there is no appeal pending. Take the second point here. Take the second stage. Tribunal says, I am remanding the matter to CIT appeals. Number of cases. So if the matter is remanded to CIT appeals, then what is the position? There on that same appeal, the matter is revived. So you can take advantage and go before the scheme if the matter is remanded to CIT appeals, but not to the AO. Look at the contradictions. Take the third instance, a little more tricky on set aside. Tribunal set asides sometimes says, I am setting aside 2 issues to the assessing officer, 1 issue to the CIT appeals. So in one appeal, I am saddled with a very peculiar situation that the CIT appeal the appeal is revived on one issue. Qua the assessing officer, there is no appeal at all on those two issues. So how do I overcome this point? How do I overcome this point? Because before the assessing officer on those two issues, that is the disputed tax which is sent back, which you have to do, or because it is not the full assessment which has gone. So here there is a big problem and a controversy. According to me, I am giving the answer. If in such a situation where part is to the CIT, part is to the assessing officer, the whole thing you have to refer it and take advantage under the scheme. Because you cannot have part acceptance of the act. Why? I will come to it a little later, that this is as per an assessment year. Definition under section 2J of disputed tax. First starting line states, this is in respect of an assessment year. So it is quite an assessment year. So with that, I think some application must be made, or the application should contain the fact that since it is before the CIT appeal, therefore this stands revived, and therefore please see that the entire thing falls within one parameter and it is solved. Fifth issue. You see, sometimes there are situations where appeal is heard, and on that again analysis of pending cases, appeal is heard, order is awaited, order is not passed. You now see the trend. Number of cases, CIT appeal doesn't pass the order. Tribunal, after 90 days you have waited, you thought that I have done very well, I should succeed, but no order. Thereafter you are surprised, you receive a notice, clarification. So you go there again. Appeal is there, but you have not got the order. So you are put in an animated suspension. Appeal heard, but no order. Such cases, 100% you should go, but then you should then weigh and speculate a little bit whether you will succeed or not, or in a case that you approach and when the order comes in your favor, then it's very difficult. This is one point. Take the case of CIT appeals. Matter is pending. Now you are, say, current. We are talking about the current scenario. CIT appeals says, see, I am also under a lot of pressure from the higher-ups. You are also aware of the CBDT circular on action plan, etc. for recovery. So I am under pressure. You are thinking of going into the scheme. In between, order is passed, raising a huge demand. That order is post the specified date of 31/1/20, opportunity lost. What happens in such circumstances? Take a still complicated case. Matter is before the tribunal. Tribunal passes an order, so it is disposed of. There is no pending appeal at all. But you file an MA, a miscellaneous application. You file a miscellaneous application pointing out that there are mistakes apparent on record in the tribunal's order under section 254. Of course, I must make a mention, I think it has become a fashion nowadays for many lawyers and chartered accountants and counsels to think that on every issue to go ahead with a miscellaneous application, which is not correct. So assuming there is a miscellaneous application, then what is the position? My opinion is that the appeal is revived. Why? Because you have a miscellaneous, what is the title? MA number so and so in ITA number so and so. your appeal is revived. So there is a pending, there is a miscellaneous application, not appeal strictly, but the miscellaneous application revives the appeal, and therefore you have a scope to get a foot in the compartment in the train to carry you in the band carriage. This is on the miscellaneous point. The sixth issue, the definition of appellant is reasonably confusing. It says that an appellant means any person. Quote, any person means SSC, person as defined in section 231, 2 into bracket 30, or income tax authority or both. Now I'm stopping here, I'm stopping. See, first thing, this is the only section where the word income tax authority is used. Everywhere there is designated authority. Definition of designated authority is there. But here, income tax authority is used, or both, in respect of a case filed by both of them, which is pending before an appellate forum, and the case should be pending. Now, if you analyze the definition in 2.1a carefully, the words used are case, legal proceedings, etc. It does not cover writ petitions, it does not cover SLP. So the question is, you are asking for legal appeals, cases, but not writ petitions and SLPs. What about them? Answer. Though not given there, if you look at section 4, subsection 3, very clearly specifies orders, writ petitions filed before the High Court or the Supreme Court. So taking a clue from section 4, subsection 3 and juxtapositioning it here, the answer is clear that they include even writ petitions and SLPs filed before the Supreme Court. See, appeals in the Supreme Court take the color of an SLP, and therefore the appeals are technically an SLP, special leave petitions, though they are in the nature of an appeal, because these appeals relate to substantial questions of law of public importance. See, just one point. Article 226, 227, words are substantial, question of law, etc. But of public importance, that phrase applies to SLPs. So here, therefore, SLPs, writ petitions are also covered, though in 2.1a it is not clarified. You get the answer in section 4, subsection 3. Then the next is the definition in 2.1b of appellate forum. What is an appellate forum? They say that appellate forum includes the Supreme Court, the High Court, the Tribunal, and the CIT appeals. Good, no problem on that. According to me, two important agencies have been left out. Why? Because admittedly there is no appeal, but it is required. Number one, Settlement Commission. See, mostly people go when they are foxed, before the assessing officer and all the problems are there. They say, we want to buy peace, let me go to the Settlement Commission. When they approach the Settlement Commission, then there is no legal case pending or no legal dispute which is there. So you can't say technically that there is a legal dispute which is pending at that stage. So settlement commission somehow should be roped in, because that is the anxiety of the people to go in and finish the matter. Take second. Authority for advance ruling. People think that I want to solve the problem. There, please note one thing very clearly. This is maybe prior to the assessment, you're going before the assessing officer, but that is the main issue on which he wants the ruling. Some mechanism to include authority for advance ruling. Or take third, dispute resolution panel, DRP. Now in dispute resolution panel, there's one important point which I want you to know. See, mostly in transfer pricing cases and other in dispute resolution panel, the idea is you go before the assessing officer, the assessing officer passes a draft assessment order. Against that draft assessment order, you go before the DR. Now the only difference here is a very technical difference, that he has not computed the tax demand. That disputed tax is not computed. The additions etc. are known. So you go before the DR. Therefore, some mechanism to include such cases of those disputed points must be incorporated here. These are some points to be taken into consideration. My seventh issue or eighth issue, seventh, let us take it at seventh. Section 263 revision, very difficult situation. There is a revision which takes place. Assessment is complete, assessment order is decided. I am going on the first scenario, you have accepted it, or on some disallowance you have gone to the higher authorities and appeal is pending on some other issue in quantum. Now there is a revision. First simple scenario. Notice is issued, show cause notice under 263, giving these reasons. That doesn't mean that you have given the submissions, therefore there is initiation of 263. So some clarification must be given to see that it stops at that stage. Then further, CIT passes an order. Last part of the 263 order is what? He can't make an addition. He gives direction to the assessing officer that in the light of the above discussions, you are required to call upon the assessee, give him an opportunity and pass an order in above guidelines which he has framed. So when a matter travels after the order from the CIT to the assessing officer to implement the directions of section 263, there is no appeal pending. Parties agreed. You can't say there is any appeal pending at all. The provisions of this scheme would be totally not applicable. Now take the question which I told you, that on the quantum, I have already filed an appeal. But on this other issue of revision under 263, the matter is sent back to the assessing officer. How do I link up that issue with the appeal I have filed? Now, one point I want you to note very clearly. First question, is it qua the particular issue or is it qua the totality of the assessment? This is the first point which arises. In other words, can I break up my points in the assessment and say that I want to take advantage only of this and not of the other? Answer, no. You can't pick and choose. You have to go either in totality or you have not to go in totality. So this will create a great problem. Secondly, just since I am on this topic, I want to deal it here. Is the scheme one assessment year or not? In other words, is it for one assessment year or another years? Can I club it? No. As I said, it is an assessment year. It is quite an assessment year. It is quite an appeal in totality. It is not individual issue-wise that you can go ahead and do it. So revision matters are very important. You will have to think over all these things. Take the illustration further. In 263 order passed by the commissioner, matter is pending before assessing officer. You file an appeal before the tribunal against the order of 263. Matter is pending. Then in that case, you can take advantage. Because matter you have challenged of 263, then an advantage can be taken. But where no appeal is filed or there is no appeal pending, but a mere direction given, then definite difficulty. And on certain issues of quantum you have gone and not on others would also create a little problem. Come to the eighth issue. The eighth issue is again, say for example, there is a capital expenditure. On capital expenditure, depreciation is disallowed. And you are in appeal on that issue. Or take another better illustration. See, trading in shares by you, whether it is speculative or business income or income from other sources. Or take another better illustration. Income from renting, whether income from house property or income from business, all these are debatable, contentious issues. Take the last case, rental income, whether business income or house property. You are fed up of litigation recurring every year, so you take advantage of the scheme. So question is, if you admit for 1 year, would it mean acceptance in all years? This is the issue I am bringing. Just try to see what I am saying. Does it mean that for one assessment year, I agree for an addition? Would it amount to acceptance in other years? Now here I want to point out. In all earlier schemes, you go through it, there is this particular clarification which says that if you have come forward and made an acceptance, here given the point, it does not amount to acceptance. I give you a specific illustration. In the recent KVSS scheme, a circular was issued. The circular, which is in the nature of frequently answered questions, FAQ, specific question. If I accept this particular addition, would it apply to all subsequent years? Answer, no. And why? Because it is a mere acceptance and not judicially decided. Correct? No such point or provision is mentioned in this act or bill. So would it amount that once I have agreed, the cascading effect of it will apply to all other years? This is the point to be considered. Come to the ninth issue. Department's appeal. Now there are a number of departments appeal, I think so. The chairman rightly pointed out that the majority and the vast litigation is primarily because of the government, and therefore to that extent the circulars have been issued recently, very good step, enhancing the limit for filing appeals, etc. Now here there is a department appeal. What should I do? Two scenarios. Number one, first thing, I have to first sit down and calculate the tax effect. Please see, because I don't want you to fall in a trap that the appeal is pending and you go for a settlement when actually speaking the tax effect is low. So first we'll examine the tax effect. Secondly, for a department appeal, where department is an appeal, you are not in appeal. If you want to settle it, yes, it is a pending appeal. You will have to pay the tax for what the department is going in appeal, which is totally wrong. Take the third scenario. There is assessee's appeal and department's appeal. You want to settle your appeal. You don't want to settle department's appeal. Why? Because like in old trust cases, depreciation issue, carry forward of loss for trust, in spite of covered by the tribunal, they are saying matter is pending before the Supreme Court. That Pierce Leslie's case of the Kerala High Court applied till Supreme Court doesn't decide, we will not allow. Matters are pending in the tribunal on this issue. So if you have to go and settle that, your case along with that department's case, therefore you have to settle both. Why? Now come to this point. The word used in 2(1)(a) is any person or assessing authority or both. So you have to go both. But I am asking one very tricky question. In definition of appellant, which says that the appeal is pending for both in an appellate forum, they have mentioned the word tax, income tax authority, which I told you is not mentioned anywhere else. Everywhere else there is designated authority. Can it be argued and said, hey listen, for my appeal, I am withdrawing it. Your department's appeal, you withdraw it. Because the word used is also both, or both. So you also do your part, I am doing my part. It is both, we have to work together. Not possible. Because then you want to tell me that the income tax department will pay the disputed tax on their appeal. Then the entire scheme would fail. So that is not the intention. But see the drafting, I am on the drafting one. Or both. So then I have every right to say, okay, Baba, see, I am going on my appeal. You go in your appeal. We'll finish it off. Both should work simultaneously. The question is, who will pay the department's money? We are here to collect, not to pay. So the whole situation can be a little tricky in this department's appeal. I come to the 10th point. See, I come to the issue now of cross appeals. There is appeal filed by the assessee. There is appeal filed by the department. These are cross appeals, one with the other connected. Same assessment here. My appeal is on some substantial issue. Department's appeal is already covered by decision of the tribunal, not by jurisdictional high court. Maybe some other high court may have decided it, but department says there is no jurisdictional high court, we want to test it. So in cross appeals, question is, how do I answer and settle the issue? I will have to take the stand that finally, even if it is a covered issue, if I want to settle it, I have to settle both the appeals. There is no provision or the intention that you partly allow and partly not allow. It is not part issues which are permissible and other issues not permissible. That is not the issue. So therefore either you settle in totality for an assessment here or you don't settle it at all. This is the whole point. And for doing that, what is the problem? The problem is that you will be taking into account the tax of the department on your head. take the 11th. Something has gone. Take the 11th issue. The 11th issue is on loss. See, in the definition of disputed tax in 2J, third provision talks about the loss mechanism. It says that if there is a loss and that loss is converted into profit, or a portion of the loss has been disallowed, then to that extent the disallowance which is done would be the disputed amount and on which the disputed tax would have to be paid. Now, let me illustrate. Illustration is that there is a loss of 100. Assessing officer disallows loss of 50. You are in appeal on 50. Now you want to take advantage of the scheme. So, appeal is pending. There is loss of 50. So, on that 50, you will have to take it as the amount and pay the disputed tax on the loss which you has otherwise foregone. So, first the loss will be foregone. You won't be able to claim it and carry forward it. Secondly, on that loss, you will also have to pay tax. This amounts, according to me, to double jeopardy. A double jeopardy theory would apply in such situations where, number one, the question is that already an advantage has been lost by me, because in the subsequent years I have a power to carry forward, I won't be able to carry forward, and secondly, on that very loss which I have claimed, I will have to pay the disputed tax on that. This is on the loss. Take a next case, 13, 12 or 13. Issue of reopening. Number of cases of reopening. And very tricky. In reopening issue, supposing your 143.3 assessment is done. You are in appeal on one point, so appeal is pending. In the meantime, there is reassessment which has taken place. So that reassessment which is done, maybe on some information or whatever it may be, there is an addition. Now here I am coming to one point. Once the reassessment proceedings have started, following GVK Driveshaft's case, I challenge the jurisdiction of the notice before a high court in a writ petition. Number of cases, I think so it is highly advisable. Normally under reopening, I think so the rate of success would be 7 out of 10, where reopening could be challenged in the high court on preliminary point of jurisdiction or on the preliminary issue beyond 4 years or within 4 years, the jurisdictional condition not being fulfilled, sections of the provisio not being applied, first provisio, etc. So now take the first situation. My appeal is pending, but I have filed a writ petition in the High Court. But in the High Court, though the amounts are mentioned, it is only the amount, say bogus purchases or share capital amount, say information received by DDI on share application amount so and so, or bogus purchases amount. It's not the full amount which could be added. But I have challenged it in the court. I can't go into the merits in High Court in a writ. I am challenging the jurisdictional issue that the notice itself per se is badly and wrongly issued. What happens in such cases? They say that even if the writ petition is pending or an SLP is pending, in such circumstances, you have a right to approach the court. But I am asking you a question is that I am challenging in the High Court what? The very jurisdiction and the powers of issuance of notice. I am not challenging the amount, because had I challenged the amount, then the court will say you have an alternative remedy. You go and take the appeal before the CIT appeals, Chabil Das case would apply. Standard answer of the department. Alternative remedies are available to you. So in such cases, where they say you go to the High Court, and I'm challenging the notice and the jurisdiction, then how do I overcome this situation? Because as I'm saying, say bogus purchases, not the total one, or share capital. It can't be that, say, 3 sources he has pointed out. 2 are not belonging to me also. So it will be very, very tricky and difficult in reopening matters to go further in the matter of pending appeals, means including writ petitions. Take the 14th issue. TDS. See, there is a TDS issue, payment made to contractor. 194C applies. My argument is 194C does not apply to me at all. Debatable issue. In quantum, what has happened is he disallows the amount by invoking the provisions of section 40AIA. It disallows that. Number 2, so 30% tax. Number 2, what has happened? TDS officer has issued to me notice and starts proceeding under 201. Consequent 201(1)(a). So there are 2 parallel points. One is from the quantum disallowance under 40AI. Second is under section 201 of the TDS. One, rate of tax 30, second 2%. Now my argument on this issue is, both appeals are pending, assuming I have to go and settle both the appeals, as I told you. But I am pointing out to you just one judgment of the tribunal, Mumbai tribunal. Case of Pfizer, 55 SOT. I'm not sure of the page, therefore I don't mention it. 55 SOT, is it 377? I think it is just, if you can check, 377. Mumbai tribunal says that no, if once you have done it in the quantum, then on that same amount you cannot again tax under 201. There is one judgment which I want to point out. Cannot I argue that on that same amount there is double taxation? See, here I am coming to the question of double taxation on the same amount which I am getting into the problem. Come to the next point. 15th issue. Question of section 2 subs 1H. Interest, disputed interest. 2(1) I, disputed penalty. Interest and penalty. Definition very simple. Disputed tax, etc. would mean interest not charged or chargeable, and the appeal is pending. For penalty, it is the levy not levied, penalty not levied, or penalty leviable on disputed tax about is on interest. So in this situation, question is of interest where quantum you have paid, but interest you are in appeal. What happens? In such situation, section 3 makes it very clear in its table on B part that you have to pay 25% of interest, or the interest is waived. First, let me come to the penalty afterwards. Interest is waived. Now I am saddled with the situation that had I not paid the main tax, I would have paid the tax and the interest and penalty would have been waived. Now, Because I have paid the tax and the penal interest appeal is pending, I will have to pay the interest at 25%, penalty again at 25%, up to 31st March 25, beyond that 30%. So this is again a little tricky issue on how to get on penalty and discipline. Let me come now to the time limits. In time limits, as I pointed out, supposing an order is passed late and you have very little time to make the payment. Order is received, say, on 30th of March. You have 15 days to make the payment. 15 days will fall after 1st April. And after 1st April, it will be 30%. It will be additional, it will be 30. It will be additional 10%. In such a situation, there is no fault of mine. I received the order late. What is the answer? As per literal interpretation, it is on the date of payment. But I give you one concept in law. Doctrine of relation back. My argument to you is this, that if I have made a declaration and that declaration is accepted, certificate is issued, then I make the payment. But once the certificate is issued, it means that it is accepted. If it is accepted, then it should relate back to the date on which the certificate is issued and not the date of the payment. Some clarification, because see, now look at the time limit. Government is giving you this concession. Why? If you pay before 31st March, so that collection is there. But there is so much complications, there is so much of time lag, which again I will point out, the compliance is not possible within such a short period. Because if they take 15 days to give me the certificate, I take 15 days to make the payment, definitely the month is over. Then how can the scheme be effective for a lesser rate? Not possible. So under these circumstances, I am saying that the doctrine of relation back would apply under the general law principles, and once, if it is accepted and a certificate is granted, you should take that date and still get the benefit, though you are making the payment later, though in 3 the words is payable. So you have to pay, but this would be one thought for you to take into consideration. Take another tricky case. 16th issue. Say 2 co-owners or 2 partners, both same liability. Say assessment is completed on A, 100 tax, 50 interest, total 150. A says, I don't want the interest meter to run. I don't want problems with the department. He pays 150 immediately. Take B. B says, again 100 tax, 50 liability, total 150. I am ready to take a chance. I think these assessments I can face. I want to go in appeal. He goes to see for a stay now 20%. So out of that, on the tax 100, 50 is interest. So on 150, he pays 20%. So 30 he pays. Now the scheme comes. Once the scheme comes, on the disputed tax, what is the disputed tax? 100, not the interest. I have already paid 30. I have to pay 70 and finish it. 2 partners, 2 co-owners, one has paid 150, one has paid 100, taken advantage of the scheme. Why? Because he was ready to take the risk. This is more law compliant person and afraid. And in such cases, assessee can say that I have not been treated correctly and equally. And I am also, my appeal is also pending. I have paid the tax. Therefore, I am filing the declaration. Please give me the refund of 50 rupees which I have. I'm on the question of refund. Question is, just because A has paid the whole amount along with interest and his appeal is pending, as against that B has not paid, he has paid only 20% as directed. In such a situation, he gets the total waiver of interest. Unequal balances. One has paid 150, one has paid 100. I make an application to say that, see, my co-owner, he is getting advantage, I have paid interest, you pay me back at least the interest. First question. Intention of the scheme is not to refund. People have got that idea. So the question of refund doesn't matter. Such an application would not be entertained. Why? Again, the disputed tax is already paid. No, many people are thinking of also saying that on this basis I should get a refund because there is unequal. But then the problem could be what? That such application is made by somebody, rejected. Obviously, that is not the intention of the scheme. Once it is rejected, then look at the problem. Say a person, in India many people are very fond of litigation, let me tell you that. And many people are very fond of frivolous litigation. And many people get pleasure on some unnecessarily writ petitions. He goes and files a case in the High Court challenging the constitutional validity. This is an act. That point which I told you, this is an act challenging the constitutional validity that between two people, me and the co-owner, number one, treated unequally, equals treated unequal, unreasonable classification, arbitrariness, plus other points normally which lawyers invent, and challenge it by way of a writ petition and say, no, you refund me the amount. Then the whole thing and the intention is stopped, though I am making it very clear that this is not the intention of the scheme, and people who think it otherwise are also wrong. There is no refund at all in this contemplation of things. And one point I want to point out in the definition of appellant, then why include income tax authority or both? That word income tax authority implies that the appeal which is pending by the income tax authority should be solved by me or by the department, because the word is qualified or both. They don't stop there, or both. So do you want to tell me that both can go together and solve the problem? That is not the intention. The intention is that people pay, come up clean. But these are the practical issues and problems which arise, which I am placing before you. 16th issue. Say section 4. Section 4 is on declaration and the procedure. Anomaly in section 2 and section 3, filing point or filing of declaration and procedure. Just see in subsection 4.1 says that the declarant shall file a declaration in accordance to the form, rules, etc. Subsection 2 says that once a declaration is filed before the appellate tribunal or the CIT. So here it is specific, appellate tribunal and CIT. Then it continues and says then it says that it is deemed to have been accepted from the time the certificate is issued. So the important keywords is a deeming fiction is brought, deemed to have been accepted when at the time when the certificate is issued. Fair enough, good section. Come to 4.3. 4.3 essentially the intention was to deal with appeals and writ petitions in High Court and Supreme Court. But it starts with the word that where an appeal is pending before appellate forum or High Court or Supreme Court. Stop. Once you say appellate forum, that includes tribunal and CIT appeal. Because definition in 2.1b includes CIT appeal, tribunal, High Court and Supreme Court. On top, in subsection 2 you are specific. You are specifically stating appeals before the tribunal and CIT appeals. But in subsection 3, you are using High Court, Supreme Court and appellate forum. So appellate forum means, again, tribunal and High Court is covered. And what is the procedure laid down? That, say for example, let me say, because I think the interpretation is for the High Court and Supreme Court. It says, number 1, you will have to move an application to the High Court or to the Supreme Court. After you make an application, the court will pass an order satisfying itself that you are allowed to go ahead and make the payment. And that declaration or certificate is required to be annexed and furnished along with the declaration. Now, just see the problems. First, my appeal is pending before the CIT or before the tribunal. I file the application. Based on section 4, subsection 2, it is deemed to have been accepted at the time when the certificate is issued. When the certificate is issued in section 5, when tax is determined, I'll deal with it in another 5 minutes. But there it is deemed to have been accepted. Look at subsection 4.3. 4.3 says that no, appellate forum or High Court or Supreme Court. So if you include appellate forum, then tribunal and CIT appeals is also included. So then they may say, no, you go back to the tribunal, get the clearance, and then come back and file the declaration. Again, what would happen? All time and loss for no clarity, because direct conflict of words in subsection 2 and subsection 3. First issue. Secondly, look at the practical difficulties in this question. They say that if my appeal is pending in the High Court or in the Supreme Court, first, what should I do? I should first go and make an application. I make an application. After the application is made, the court will hear, pass an order, and that order I have to annex it with my declaration. For High Court and Supreme Court, this is the procedure. Now let me come to the practicality. Only in High Courts of Bombay and Calcutta having original signing, you are required to take out a notice of motion. So the man will have to first make an application, notice of motion will have to be taken out. And after the notice of motion is heard, then the order will pass. But this is High Court and Supreme Court, they will not take your word. They will tell the departmental lawyer, please get it conveyed that this is right or wrong. Get your say from the assessing officer. Correct, High Court has to protect and Supreme Court. They can't rely on words. Again, next hearing, maybe after 3-4 days, department's standard answer, appeal is old, papers not available. Again, it is adjourned. Asked, appellant told me, you give me the papers not traceable. So this way, how do I comply with the deadline and the guidelines? This whole procedure Say Vivad, say Vishwas. Where is the Vishwas? If you are telling me to go to the High Court, take out a notice of motion or an application, and then matter is heard, then the order is passed, then go and give it. It's all a matter of time. It will take 6 months, 3 months. I may go out of the scheme. I'm a genuine assessee who wants to take benefit of the scheme. Intention of government is please come forward and take advantage of the scheme. It's a noble point which is done. But look at how the implementation is squeezed in this particular form on subsection 2 and 3, therefore requires redrafting. 2 appears to be correct, 3 doesn't appear to me to be correct. It is only confined to High Court and Supreme Court. Appellate forum is wrongly included. Then you have another subsection, 5 and 6, which says that once you go, you waive all your rights. You have no right thereafter in any forum, even in conciliation, mediation, etc. You have given up all your rights, agreed. So there should be no litigation. And another point in section 7, that once you have paid, there is no refund. Money is gone. Right or wrong, once paid, no refund. But my opinion, if the application is rejected, nothing is mentioned in the Act that you can't make a second application. You can make as many applications within the time limit. That is sure. Please note that applications, once you have made the declarations, then the competent, then the designated authority would be any commissioner or any other person appointed by the principal commissioner, and the designated authority under such situations would compute the amount payable, and the computation would be then given to you. Then within 15 days you make the payment. So what is there in section 5.1? Section 5.1 talks about certificate. Section 5.2, last line, talks about order. So once you have made the payment, then the order is passed in subsection 2, and 3 says that once the order is passed, it cannot be challenged in any other forum. Subsection 6, 16th issue or 17th, forget that name, is on the question, very good section. It says that once a disputed tax is paid and the application is accepted, first, it starts with that very good section. It says that the designated authority will not initiate prosecution. Very good. For the offense, will not, it's not prosecution, will not initiate any offense. According to me, interpretation, prosecution, or charge interest, or charge penalty. Very good. So that fear which people have in mind, if there is no initiation of prosecution, then once the scheme is accepted, it will not be initiated. That is for sure on the wordings of section 6. In fact, it starts with that. That is very good. 7 talks about that there is no question of refund. And now let me come to the last section, section 9. It has 12 sections, other are procedurals of what, but come to a very difficult section on this act will not apply to the following, A, B, C. My question is that it will apply to whom? I am asking you first question, it will apply to whom? It starts with first A, B and C. A, for any person, A in respect of tax areas. So it is only in respect of tax areas. Now they brought in 5 categories. Number 1, all cases and appeals which are under section, all cases under section 153A or 153C. So if you are subjected to search then you are out. Actually speaking, it is all the search cases which are required to be done. And they are only excluded. One more point, I'm stopping at that because otherwise this will go on. Section 153A2B, broken period. You know, there are 6 years and then there is a broken period. The block period of the main assessment, block assessments, is for 6 years, not of the block, not of the broken period. For the broken period, you have a right to go. That doesn't encompass itself within 153A or 153C. First. Number 2, cases where prosecution is initiated. Now this gives a very big problem. So all those cases where people are saying, Baba, we don't want to get into the chapter, finish off the matter, but there is prosecution. So if there is prosecution, you can go. And please see number of cases like TDS non-deduction, some minor tribal points. Why this was inserted? And apparently, compounding fees would be much larger than this amount. You're getting 30% at your normal rate. Compounding will be much larger. Maybe that way. But I think this point of, in fact, what section 6 says is the right direction. Continue that. Please remove about the prosecution. People, I think they will come and be clean. So this is the second point. Third point, any person who has or on whom notice etc. has been served for money trashed abroad for in respect of undisclosed foreign income or undisclosed foreign assets. So the Black Money Act comes into the picture. Number 4, all those cases where there is definite information received concerning section 90 and 90A means all the transfer pricing and international transactions where there is some information received, HSBC Bank and all those informations, they cannot apply. And number 5, something unheard of, cases where CIT has given enhancement notice under section 251. Now, ironically, somehow or the other CIT says, I want to enhance and gives me an enhancement notice. He may ultimately be right or wrong. But once he has issued me an enhancement notice under section 251, I am barred. I cannot apply under this. This is all what A says, starts with the word on tax areas. B talks about 2 persons who are being prosecuted or on whom some prosecution or other proceedings are launched under the Foreign Exchange Act and the Smuggling Act. Okay. But C, look at C how it is drafted. To any person on whom prosecution has been instituted, starting with, for any offence under the Indian Penal Code, for any offence under IPC. Number 2, for any offence under the narcotic drugs, under benami transactions, under money laundering act. And finally, look at the last 5 words. Any civil liability which is instituted. 2 questions. First point. Words are Indian Penal Code. Friends, do you know how many sections Indian Penal Code has? And do you know even abatement? Somebody goes and files a defamation case against you, that you will also fall within that. But my argument before you is that the word Indian Penal Code in subsection C has to be restricted, confined to prosecution which are initiated under the Indian Penal Code, the Income Tax Act only. It can apply to everything. Otherwise, some somebody unnecessarily, a big person wants to go, there is some defamation case, there is some abatement case, there is some other issues, 420, that cannot arise, that cannot be the intention. Similarly, the last words, that any civil liability instituted. Now that doesn't mean any civil liability. That means some monetary suits between landlord and tenant. Recovery of amount would also be covered. No, that is not the intention. Intention could be restricted cases connected with income tax act, maybe, giving two instances. It could cover all those attachment of property cases and civil liability. Schedule 2 comes. Or cases maybe under 138 negotiable instrument or not directly connected, but that because that one provision here is narcotics and smuggling etc. of drugs. That is not connected with income tax, but that is the tainted money. So on that basis we can. So this clarification must be done on Indian Penal Code. Otherwise I think it would make senseless reading. And what is the implication of the words civil liability? Mr. President, I want to point out a few other things. Number one, this scheme is worth going for if you have a weak case, or if you have been caught, let me put it very bluntly, with your pants down, and you know that there is something wrong, please go ahead, avail of the scheme and come out very clean. Number two, cases of demonetization. Now, demonetization took place on 8th November 2017. 16. Year ending is 31st March 17. And the assessments got over on 31st March, December 2019. Now, all those demonetization cases where there is no answer and explanation, worth going. One danger, I want to point out, the additions which are made are also with regard to section 115 BBE, where the rate of tax is 60%. The interest and penalty is very minimal. So you have to think about that here, you have to pay 60% because of the disputed taxes. Number two. Number three, take the case of penny stocks. Now, lot of penny stocks, right or wrong, I don't know whether you have noticed, all these cases are literally choked before the commissioner and before the tribunal. They're all pending. Good chance you can go ahead and finish it off. Take fourth case, reopening cases, where the reopening relates to old years, like for example 12, 13, etc. Go ahead and do it. Why? Because the interest meter, assume you lose, would be from 12 to this, which would be almost 2 times or 3 times the amount. Better to go in for such cases, I think so. These are some guidelines which I had in my mind to tell you. Let me conclude by saying one thing. On the whole, the act which is likely to come is very good. Advantage should be taken, and this is required to fulfill the aspirations of the government that people come out more clean. Recently it was reported that in a population of 1.30 billion, 1.5 crores pay taxes. Now if 1.30 crores individuals pay taxes, there is something really wrong in the system. But in India we have that habit if there are 1.5 crores citizens paying taxes, the criticism against the budget and the policies would be 15 crores people. Even those who are not paid will say and criticize. This attitude is wrong. And I think if the creases are done and ironed out properly, the government action on this scheme should be applauded and should be considered to see that people come out clean. My last comment. In this budget, the rates of taxes have been tinkered a lot. Up to 5 to 15, 4 slabs, 2.5 gap, then the others. Let me conclude by telling you that the Indian mind to invent tricks, to invent ingenuine points of evading tax knows no bound and is unchallengeable. Therefore, this practice is already entrenched in India for the last 65 years. To get it out from the system, which the government is trying, is very difficult and complicated. Though the government is making a sincere effort on it, but you should see that this is in the blood now. So to remove it, let me give you one suggestion. Your chamber can carry it forward. You want to make people pay taxes? You may have to bear for 1 or 2 years. Do it this way. Abolish all deductions. Abolish all exemptions. 5 to 30 lakhs, 10%. 30 lakhs to 1 crore, 20%. 1 crore and above, 30%. No surcharge, no education cess, no cess whatsoever, and come out with a caveat: if you pay it honestly for 2 or 3 years, no scrutiny assessment. See the magic. People will come out by themselves and pay the tax. This is the solution which is required, rather than to have complications. I hope the government, we have made an effort on this. The whole idea is to see and put before you and the government and the representations, if you want, to be made by the chamber or whoever to the government, to say these are the points, these are the controversies, these require clarification for the success, because the chartered accountants, the lawyers, tax practitioners work hand in hand with the government. Thank you.